say multiple rounds, a state prisoner has had a state court, intermediate state court, final Supreme Court, a district court, and a court of appeals. But in federal court, a prisoner only has 2 rounds or 3 rounds of review, correct?
That's correct. What state prisoners have that federal prisoners do not is they also have state post-conviction review, which serves as an additional level of review that federal prisoners do not have. They also have, of course, the right to appeal any federal claim to this court, even on direct appeal of their state conviction. And we actually see a collateral estoppel bar in 2244C that applies only to state prisoners.
I'm sorry. Please. Counsel, I don't want you to give up your first argument on jurisdiction. I know that in a previous statement I made in this very case, I suggested that it was wrong. But your brief gave me great pause. Don't give up on it. All right? Your position is that the cross-reference barring jurisdiction does not unambiguously incorporate the cert bar that exists for state prisoners, correct?
That's correct.
And our case law is replete that to deprive us of jurisdiction, it has to be clear.
That's correct.
All right, and unambiguous.
Correct.
And this is not. All it says is that successive habeas motions filed by federal prisoners, quote, must be certified as provided in Section 2244 by a panel of the appropriate court of appeals, right?
Correct.
Now, that's not sufficiently clear because this court is not a panel of the Court of Appeals, right?
That is correct.
And so it's speaking about whether a full panel could hear it, not whether the Supreme Court could hear it, correct?
That's correct. To be clear, we are not giving up that argument.
All right.
We are simply saying, as we did on page 15 of our reply brief, that it's not necessary.
Because of the Castro argument.
And our other narrower arguments.
Right. But any review by this court of a panel cert decision is not part of how the panel certifies a successive filing, correct?
That's correct. Our argument is based on the text of 2255H, which incorporates the parts of 2244 that, quote, provide for how a motion is to be, quote, certified by a, quote, panel of the appropriate court of appeals. And our position is that incorporates B3A through D, because those provisions do just that, but it does not incorporate E, which comes into play only after the certification determination has been made, and it provides limitations on further review in the form of rehearing and certiorari.
And that doesn't your